Okay, so for today, I want to give a really quick video because as I'm grading most of your papers, I'm seeing that you're really struggling with the explanation and the application. So hopefully by the end of this video, you'll have a little bit more clarity. We're going to start with explanation. As a reminder, the explanation consists of several parts. The purpose of explanation is to set out the cases that have applied your rule in the past. The purpose of this is to show the reader how the courts take the rule, apply it to a certain set of facts, and have an outcome. You can give the rules all you want, but until the reader can see the application of the rule in action, the reader won't understand how it'll apply to the facts in your case. So to do that, you start out by organizing your cases by hooks. A hook is a concept. It's a concept from your rule statement that needs to be explained further. Within the hook, you now start out with the most important case, and the most important case most of the time is going to be the case that has the most analogous facts for you. So in your application section, if you're struggling making an analogy, then that's probably not the case that you want to use as your first case under your hook. Find the cases that you can most easily analogize to as the first case and the first FHR in your hook. So after the hook comes what I just mentioned is an FHR for the case illustration. Your case illustration is doing what I just talked about. It is showing the reader how the courts have applied this portion of the rule. And by doing that, you're explaining how the rule works. So to do that, you do what's called a case illustration, and the case illustration has three parts: facts, holding, and rationale. So you supply the most legally significant facts, and it's the facts that are relevant to the insular issue of the rule that you are trying to explain in that hook. You provide all of the facts that's needed for the reader to then be able to understand the court's holding on that insular issue. And after the court's holding, you then provide the rationale. When you are writing your explanation section, try as much as you can to paraphrase. Don't quote too much. And if you are going to use a quote at all, make sure it's a quote to law and not a quote to the facts of the case. And remember, you're focusing on the insular rule concept that you're trying to explain in that hook. You're not focusing on the entirety of the case itself. So here's a rule from one of your papers. I'm not saying it's a great rule. I'm not saying it's a bad rule. I'm just using a rule that I pulled out of a paper. An individual can be recognized to hold the invitee status under Florida law when the property owner's action on the property reasonably led the visitor to believe that he is welcomed and invited to the premises for their intended purpose. An invitee can lose his status when he enters a part of the premises that is beyond the scope of his invitation. Conversely, an individual can be considered an uninvited licensee when he enters the premises exclusively for his own convenience without expressed or reasonably implied invitation. Thus, his presence is merely permitted or tolerated by the landowner. So when you look at this rule, what do you think needs to be explained? So what do you think the hooks from this rule should be? Take a second and think about it in your head. So here's where I think the hooks lie in this rule. I think that the first hook is going to be explaining what it means to reasonably lead a visitor to believe that he is welcome and invited to the premises for their intended purpose. The next thing that I think needs to be explained is what does it mean to enter a part of the premises that is beyond the scope of an invitation? What limits an invitation and its scope? And the third would be enter premises exclusively for his own convenience without expressed or reasonably implied invitation. So those are the three things that I think need hooks out of this rule. And if that's so, then the first hook concept would be what it means to reasonably lead a visitor to believe that they are welcomed and invited for an intended purpose. So what is an intended purpose? What causes somebody to reasonably believe something, etc. Now that you know what your hooks are, now you think of your FHRs. What facts are going to go to that hook? What case shows the best holding for that hook? And what is the court's reasoning? So here's a case illustration. The case illustrations are not related to that rule. I'm just showing you the case illustration. I'm not showing you a hook because many of your papers are lacking in your case illustrations, and I want to talk about it. So here's the first one. In ARP, a pedestrian was injured while walking down a path with some loose paver stones adjacent to a shopping center's property. She was taking a shortcut to return to her house. The court held that the plaintiff was, at best, a licensee. The court reasoned that the pedestrian could not have reasonably believed the area was intended to be used as a convenient path because of the storm drains next to the path. Moreover, the court noted that the pedestrian was not on the property to visit any of the businesses in the shopping center and that the property's design could not have been interpreted as an implicit invitation. So, first thing I'm going to say is that is a lot more information than I'm getting from most of you. But let's look at it. Remember that I said the facts that you give, the reader needs to know all of the facts before you give the holding and the rationale so that they can understand the holding and the rationale. Well, here, all we know from the facts section was that the pedestrian was injured while she was walking on some loose stones and that she was taking a shortcut. It's not until you get into the rationale section that you learn about storm drains, that you learn that she was taking that she was that she didn't buy anything from the businesses or the design of the property. So that needs to be in your facts section before you get to the rationale so the reader can understand why the court reasoned as it did. Before I leave this and before I get to the next one, I also want to note that after every single one of these sentences, there should have been a citation. There were citations before I put it on a slide, but it made the slide too long, so I took them out. So all of the citations have been omitted, but every single one of these sentences should have been supported by a citation. So let's look at another one. In ARP, a pedestrian walked through a pathway containing storm pumps located in the utility easement area of a shopping center. She was using the pathway as a shortcut and was subsequently injured. The court held that the pedestrian did not have an invitation to use the pathway, making her a licensee, because no person would reasonably believe that a pathway near storm pumps was intended to be used, was designed for, or constructed as a walkway for convenience. So here we have a lot more information, even though it's much shorter. We know that the path that she took was near storm pumps. We know that it was in an easement adjacent to the shopping center. We know that she was injured, as well as her taking a shortcut. So here it's easier to understand the court's holding and the court's rationale. On Canvas, in the module resource section, I've posted something called the CREAC checklist. The CREAC checklist has a list of things for you to review for your conclusion, your rule, and your explanation, for you to determine whether or not you've met the criteria of a CREAC. It's kind of like a self-guided rubric without it being graded. So now let's go to application. Remember that application is meant for you to specifically refer to the rule and the explanation section and apply those to your case. It's where you do the work for the reader as opposed to just giving them the law and letting them make a conclusion. It's where you step by step make that peanut butter and jelly sandwich and walk them through how you got to your conclusion. So when you do that, you don't want to waffle or be wishy-washy or be ambivalent. You want to be strong and decisive. And your application has to be explicit and specific. Cannot talk in rule generalities. You have to use the facts from your case. So to write an application, you need to start with a point of analysis. I'll get to that in a minute. You need to remind the reader of the rule concept that you are writing about. You need to remind the reader of the explanation cases that were used to explain that rule concept. And you need to apply that concept to your case by analogizing or distinguishing the cases you used in your explanation. So if you looked at the score sheet, you would note that the very first thing under application in the score sheet was this. Application begins with a sentence that signals transition to application and summarizes the result when applying all aspects of the rule to the facts of the client's case. In your reading, when you read one conclusion or one legal argument, it talks about conclusions, and there are actually 3 conclusions in a CREAC. There's the opening C, there's the closing C, and there's a mini conclusion right before you get to the application of your case. That mini conclusion should incorporate all of the information from your hooks and make a conclusion on how your case is going to come out. So here we have an transition sentence. First, you have to signal that you're transitioning to your case. So in the current case, in this case, although Mr. Jackson was an invitee when he originally went to Walridge to pick up his prescription, his status changed when he left the store's parking lot and returned solely to retrieve his wallet from his car to pay for a food order at a nearby business, making him a licensee. So this transition incorporates 3 hooks, one about invitees, one about licensees, and one about status change and why. Immediately after that sentence, if you're in the first paragraph of your application, you need what is called a point of analysis. And for all subsequent paragraphs in your application section, when you're going to a different rule concept, you need a point of analysis. A point of analysis is basically the hook for the application section. So here we're just going to say that the point of analysis is Mr. Jackson returned to the parking lot for his own convenience to retrieve his wallet and not as a customer of Walred's. How do you determine what your point of analysis is? Well, you determine what your point of analysis is based on your hook. So if one of your hook concepts was a customer enters the premises for a purpose directly connected to the owner, then your point of analysis, which is now using your facts to basically prove that hook, is Mr. Jackson returned to the parking lot to retrieve his wallet to pay for a product at another store and not for a purpose directly connected to Walrid's. So you showed how it wasn't connected to Walrid's because he was getting his wallet to pay for something at a different store, and then made the conclusion that mirrors the hook. Once you have done a point of analysis, now it's time for you to do your application. Remembering that your application includes non-conclusory, thorough explanations of the way the rule applies to your facts, and you need to display consistency, and you need to reference your rule explanation section by analogizing or distinguishing or reconciling the cases that you have in your explanation section. Quick summary of the process. You state your point of analysis. Now you construct your analogies, whether they be comparisons or distinctions, or the cases that you use in your explanation, and then you need to explain why it matters. Remember, your goal is to describe the facts that are legally significant in your case. You don't need all of them. You need to explain how those facts lead you to your conclusion, and you need to explain why all of that matters. So let's take a look at some of your application section. Many of you are failing to analogize. You're simply saying something like in post, Mr. Jackson was on the Walridge premises for a purpose directly connected with the business and the land was held open to the public. There's no analogy there. You're just saying that your case is like post, but you're not showing why, and you're not saying why, and you're not even reminding the reader what post is about. So the reader would need to go back further into the paper to reread what you said about post to be able to understand what you're saying here. Same thing with this one. Like Brian, Mr. Jackson was invited onto the property and was owed a duty of care because of his visitor status. Again, the reader would have to go back to where you discussed Brian to understand what Brian was about to be able to determine why your case is like that. Furthermore, the court can distinguish Iber from the present case because Mr. Jackson came onto the property for a business purpose during business hours and therefore was not an uninvited licensee. To understand this sentence, they need to go back and read what you wrote about Iber to, one, determine if they are different or distinguishable, etc. So the correct way to analogize and distinguish is to do something comparable to this. Like in ARP, comma, now you give the legally significant fact from ARP that you want to highlight for the reader to remind them what ARP was about, comma, here, now give the analogous fact from your case to remind the reader how the cases are connected. Then you provide a citation. Your citation is going to have a C in front of it because ARP does not stand for anything in your case. So it doesn't directly stand for the proposition of the entire sentence. And after that citation, you need to add more specific facts of your case to elaborate on the point that you're making. Same way to distinguish, you would do, unlike in ARP, comma, put the legally significant fact, comma, here, put your legally significant fact that's like ARP, citation, and follow the citation with specific facts. Remember that you're comparing A to B and A to B. Not every sentence has to look like, you don't even need to use this format if you get the same thing done another way. I just see that many of you are struggling, so I'm providing a format for you to use as you're learning the skill. This is not a formula. This is not a formulaic approach. I'm just trying to give you a tool to use so that you can better remember what it is you're supposed to be doing. You don't want to fact dump. You don't want to lay out all of your facts without any law and nothing for the reader to connect what you're talking about to. So here in the current case, Mr. Jackson was on Walred's property for the purpose for which it is held open to the public to pick up his monthly prescription. Upon arrival at 6:30 p.m., he was notified that his prescription was not yet ready and would be available in 3 hours. To pass time, Mr. Jackson decided to explore the nearby boardwalk and leave his car in Walred's parking lot in a parking for Walred's customer-only marked space. Tried to buy food, but found it was cash only, so he returned to Walred's to get cash, realizing it was only 8:15 p.m., and he still had time to do so. Moments after reaching his car, Mr. Jackson was viciously attacked. There is absolutely nothing connecting those facts to anything. Then, according to Post, Mr. Jackson would be classified as an invitee because his presence on the premises was related to receiving his medication. I'm not sure how you get there when he went to return to Walred's to get cash. And then similar to Post, Mr. Jackson's purpose for being on Walred's premises was because he was invited. I don't think that any of these facts actually show invitation. So don't fact dump. Next, make sure that you're comparing like things. Here we have a sentence similar to the court in Community Christian, which found the visitor was initially an invitee because he purchased an item at the store. Here, Mr. Jackson bought an iced tea at Walred's. This is not comparing like things. If you look at it, it's actually comparing the court to Mr. Jackson. So when you want to compare like things, you would say something comparable to this. Similar to the visitor in Community Christian, who was initially an invitee because he purchased an item from the store, here Mr. Jackson was initially an invitee because he bought an iced tea at Walred's. Make sure when you are discussing your case in your application that you actually use explicit facts. Mr. Jackson's re-entry was a reasonably implied invitation because it bore indirect relevance to Walred's business purpose. Instead of saying that, tell me what the indirect relevance to the business purpose was. So Mr. Jackson's reentry was a reasonably implied invitation because he was told to return 3 hours later to pick up his medication, something like that. But use your facts. Make sure that you use the packet. What facts led to this conclusion? It doesn't have to be that he was told to return in 3 hours. What facts would lead you to that conclusion? Remember that when you are giving facts, that you link your facts back to a legal point. So you're going to have to make a legal point first, and then you're going to have to link a legal point back at the end so that they're sandwiched with legal points. Mr. Jackson came to Walridge to pick up his asthma prescription. His prescription was not ready, so he bought an iced tea and left the premises to burn off time while he waited for his prescription to be ready. Mr. Jackson came back to Walridge parking lot to get some money out of his car to eat a sandwich while he waited to pick up his prescription. There is no law connected to this. This is just a statement. So my response to you is, so what? What does it matter that he did all these things? What does this relate to? Your application also needs to include counter arguments. You cannot ignore the other side. If you are having struggles with counter arguments, I suggest that you read section 8.4 of chapter 8 of your text. It tells you that you can use an implicit counter argument or an explicit counter argument. Implicit counter arguments are better because you're going to want to use those again in persuasive writing. Both are permissible, but again, in your case, since the case hasn't been filed, Walridge isn't arguing anything. And if you determine that Mr. Jackson is a licensee, this case will never come about. It seems silly to tell me what Walridge is going to argue. Instead, just use the law. You can do that by using a signal and a parenthetical in your explanation to show law that goes against you, and then apply that case in your application. So what does that look like? So outside of your case, totally different fact pattern. In Jones v. Davis, the court held that ice cream was healthy because it contained calcium. Now here you have a contra, which of course indicates that there was a case that decided the other way. Callaway v. Titus, and the parenthetical explanation says, concluding that although calcium is good for bone density, because ice cream also increases cholesterol in those with pre-existing heart conditions, ice cream is unhealthy. So now, if you want to do a counter argument and you want to say that ice cream is healthy, unlike in Callaway, where the ice cream consumer's pre-existing heart condition caused his cholesterol to rise, here, Ms. Swanson did not suffer from a pre-existing heart condition. The court likely would find that eating ice cream would not negatively affect Ms. Swanson's cholesterol levels. So you're using a case that you had in your explanation section, but didn't talk about explicitly, but you had a parenthetical explanation, and you're doing a comparison in your counter argument. Please note that this is the only time you can talk about cases from your parenthetical explanations in your application. If you are looking for a case that supports you and you want to analogize to it in your application, it needs to be out of an explanatory parenthetical and in the text, because things in explanatory parentheticals are not actually part of the text. They're part of a citation. Remember, whether it's application or counter argument, that you need to analogize your facts, and then you have to link those facts to law. Ask yourself that every single time. For that same CREAC checklist that I posted on Canvas under Module 7 resources, there is also a checklist for the application and the conclusion section. I hope you find it helpful. I suggest that you try to use it as you're trying to revise your discussion section. That's it. It was just a quick down and dirty video because I'm seeing a lot of problems and I wanted for you to hear about the problems from me before the weekend. So if you choose to revise your discussion section over the weekend, you have this to help support you. I hope it helps. I will see everybody on Monday.